Please be seated. The court is now back in session. In order to respond to the technical aspects regarding the way of putting questions to the witness by Counsel Michael Canavas, that is the International Council for Inquiry. The Chamber will give the floor to Judge Cartwright to clarify and respond to these issues. Judge Cartwright, you may proceed.
Thank you, President. The trial chamber has deliberated briefly on the issue that you raised, Mr. Carnavas, and on behalf of the chamber, I wish to acknowledge first that it is understandable that those coming from different legal systems have some discomfort with a different legal process. However, it is the procedure upon which this court functions, and it is the procedure that was agreed as long ago as in the agreement between the Royal Government and the United Nations. Therefore, the general rule is that there is a legal presumption of the integrity of the investigation, that any concerns about the methods or the subject matter traversed during the investigation must be raised during the investigation. And now at trial, as Judge Levagne has expressed, the investigation is treated as the starting point and can be rebutted only in exceptional instances. Any such rebuttal must relate not to technical issues, but to substance. And in raising an exception, you must satisfy the trial chamber that you have well-grounded concerns about the reliability of any part of the investigation. To use a well-known common law term, you cannot embark on a fishing expedition. It seems to the trial chamber that most concerns about what a witness might have said during an investigation and what he or she is saying now in evidence can be dealt with quite simply by asking the witness. And for that reason, for these reasons, the trial chamber is yet to be convinced that the playing of a tape or a portion of a tape will assist in any way. You need to satisfy the trial chamber that there is a well-grounded reason for going back inside the investigation and investigating it. Therefore, we would prefer and so rule that you simply ask the questions that you have of the witness. Now, I'll just pause here to make sure that there's nothing the President wishes to add to what I have said.
Thank you, Judge Cartwright. I have nothing further to add.
Thank you. And I understand the ruling, and I appreciate the ruling. And in the future, where we do endeavor to do this, we will see whether we have exceptional circumstances and raise them because now we understand the court's position. And I should note, I'm told by my colleague that when I did mention that one of the national investigators was related to a prosecutor, that wasn't properly translated. You know, he's actually a younger brother of one of the national prosecutors, and this is the same investigator involved in the matter in which we filed an application E2224 dealing with another witness. Now, getting to...
That's right. You may proceed.
I'm sorry, Mr. Carnivas. I just need to clarify that point as well. Any suggestions of impropriety are themselves improper. And a suggestion that someone is related and is asking the trial chamber to draw an inference of impropriety. Therefore, it is not acceptable in court. So I do apologise for interrupting, because I know what it's like to be on a train of thought. So please proceed now.
Thank you. And I apologize. I'm learning as I'm going along. I'm trying my level best. We do try to be professional, and sometimes we don't get it right, but we do endeavor. And we appreciate the court's understanding and indulgence. Sir, let me ask you a simple question. The day before you were interviewed on tape, did you have a meeting with the investigators? And if so, can you please tell us where it was located?
One day prior to my interview, the team met me. They met me while I was teaching at Old Jamlong Primary School.
Thank you. Now, yesterday, my colleague showed you a portion of your interview, where, for the very first time, you mentioned a pong, and of course, it's not anywhere in the summary before, which would suggest that pong was discussed the day before. Do you recall whether, indeed, you discussed pong the day before you went on tape?
I cannot recall that. Before the audio tape started, I could not recall whether the issue regarding pong was asked.
Okay, so you can't recall. Well, did you have an interview on the day that you were tape recorded? Will you also ask questions prior to being interviewed?
Before the interview took place, we chatted a little bit, but I cannot recall that conversation at the time because we do not have anything in writing and it was not taped, and it's been 3 or 4 years now.
What about your conversation from the day before? Can you please tell us at least how long that lasted? How much chatting was done the day before?
If I can recall it, the conversation was not long. It lasted about 1 hour. And at that time, I was busy teaching my students, and they waited till the break time. Then they came up to me and we had a conversation. The break was at 10 a.m. and I think the conversation lasted about 1 hour.
All right, thank you. Let's move on a little bit to when you actually read your statement, the summary of it, and then you signed it. And the reason I'm asking is because in testifying here over the last 3 or 4 days, you've indicated that at times you were speculating when you were providing answers. Is that right?
There were several words in my statement back then, including perhaps, maybe, or it is possible that, or this, because at that time, the OCIJ investigators did not inform me that those words cannot be used in the court of law. They only tried to put requests to me to explain, but they did not tell me that I cannot use those terms.
All right. And one of the other phrases that you have used, in both of your statements, is, as I understand it, as far as I understand. Words to this effect. When you say, as far as I understand, are we to interpret that in those instances you are also speculating?
At that time, the team requested me to explain to them. And my explanation, of course, based on my understanding. It is not the fact. It is equivalent to my analysis, or you can say my speculation, because it is based on my understanding.
Right, and that was my next question, because there are some instances where you also say, even here in court, according to my analysis. So when you say according to my analysis, especially when the investigators were showing you documents, were you speculating at that time as to how to interpret the document or the events described in the document?
My response was based on the question put to me regarding the matters or the events, and of course based on the level of my knowledge, my response would be accordingly.
Thank you. Now, yesterday, and I just want to also make sure that we understand that principle that you are speculating when posed those sorts of questions also applies when questions are posed from the bench. Let me refer to a question that was posed to you yesterday, and this can be found on page 6, it's right below 09.16.53. You were asked by one of the judges, therefore, is it possible that it was Saul Pim, or is this not certain? Could it be a possibility? I'm not asking you whether or not you know this, but you think it's possible that it could have been Saul Pim. And your answer is, yes, that is possible. Now, using this as an example, when you are answering these sorts of questions, are you speculating as well?
Witness, please wait. The prosecution, you may proceed.
Your Honours, I would object to the characterisation that my learned friend just put on the witness's description of his responses. There's a subtle but important difference. If we return to the witness's last response, where he used the word analysis, he said, analysis which is based on my understanding, or an explanation based on my understanding. Now, there is a significant difference between one speculating without any knowledge of the fact and one who had more than 8 years' experience, based on this witness's testimony, in the procedures of communicating and in the systems that were employed. We would submit respectfully that when the witness gives, to use his words, an analysis based on his extensive experience and knowledge, that is not speculation. And that is why I object, because my learned friend is characterising that analysis as speculation. And I would invite Your Honours to give a direction to counsel and to the witness as to this very important difference, which I think may have been lost, possibly in translation and possibly in the way that counsel are characterising the evidence.
If I may briefly respond. It's rather rich for this prosecutor to stand up and then go ahead and give a closing argument while also telegraphing to the witness what he should be saying when he was accusing the defense of doing the very same thing. You have his answers. Obviously, we are getting started. I asked him a question. He gave us an answer. I then went to a concrete example where it wasn't based on analysis, but where he was asked to speculate. So we leave it to you, Your Honors, to decide. And, of course, the prosecution will have ample time to clarify in their closing brief what the gentleman meant when he says he is based on his analysis. But my question went to what was being asked of him by Judge Laverne, which had nothing to do with analysis. So, in addition, and perhaps my learned friend was being polite, or I beat him to the gun and beat him to the opportunity to stand up, that objection was belated.
President, the bench would like to give the floor to Judge Cartwright to rule on the objections to the last question and the reply by the International Council for Evidentiary. You may proceed, Judge Cartwright.
Thank you, President. The trial chamber allows the objection from the prosecutor and notes that the question put to the witness was based on a presumption that Judge Levin had asked questions which invited a speculative answer. That is not correct, and it's necessary to specify that the word speculation in English means guess. In other words, no factual basis for making a statement. The witness's testimony has been translated as analysis, which is a statement made by the witness which is based on facts that he knows. Consequently, use of the word speculation is not acceptable in relation to what this witness has called analysis. So, Mr. Carnavas, if you could possibly avoid the use of the word speculate and use the more neutral terms when you are challenging this witness. Thank you.
Thank you, Judge Cartwright. Well, we'll get back to this issue momentarily, but let me move on, and we'll get back to the issue of your analysis at times. Now, you told us that after listening to the summary, you went ahead and signed it, knowing that you were signing it as a statement under oath. And then you were asked a question here in court concerning a reference that you made to my client, Mr. Ingsari, and the Ministry of Foreign Affairs. And I'm referring specifically to page 13 of document E3/64. The Khmer ERN number is 003280352237. French 00411703-04. In English, it's 00334054. And if you look at it, you will see that you were asked a question. You said that Mr. Ingsari had his own working place. Were there any telegram translators at his place? Answer: Ingsari had his foreign affairs ministry, so he had his personal telegram translators. Let's stop there for a second. When you say, so he had his personal telegram translators, was that you saying that, or was that something that was put there by the investigators based on their understanding as to what you had told them?
The statement was mine. It was not an addition by the investigator.
All right. So when you say, so he had his personal telegram translators, when you said that, you were not speculating. That was a fact that you knew back then.
The thing happened long time ago. I am not certain as to who the translators of the telegrams were. But later on, I found out that whatever telegrams that were not sent to my unit, and he had other telegrams to be sent to his foreign counterparts overseas, he must have had his own means to send the telegrams overseas. He might have had other means based on the actual circumstance at the time. At the initial stage for foreign communication, they sent the telegrams to my unit, and those telegrams contain the signature of James and others. But later on, I cannot recall, but I myself did provide telegram training to the staff members of Ministry of Foreign Affairs in terms of decoding messages, but later on I did not have any contact with the Ministry of Foreign Affairs.
All right, well, we're going to get to this. So are you telling us for the first time, because it's not in your statement and it wasn't mentioned before in your testimony, that you actually went to the Ministry of Foreign Affairs and gave training?
I was the trainer for the telegrams translators of Ministry of Foreign Affairs, and that location was the former Prime Minister's office.
Let's go on and see what else you say. When he, meaning Ing Sari, wanted to transmit a message, did he send a messenger to take it directly to the radio communications unit at the old American Embassy? Here you say, I did not know clearly because it was not in my framework. Obviously, you stand by that statement.
Yes, I stand by this statement, and I was not sure. I did not know whether or not that was sent to the U.S. Embassy, or he had other means to communicate this message through other diplomatic missions in Cambodia. I did not know the means of that communication.
Right. And then you go on to say, then the next question is, when they needed to send a telegram overseas, did they use the radio communication site at the old American Embassy? And there you say, maybe. Maybe they did. Do you see that?
Yes, I do. I see it. That's why I would like to say that I did not know. That should be the answer.
Well, that's my whole point. This is the purpose of the exercise. So when you say maybe, you are suspecting. You don't know for a fact.
Yes, that is correct.
Now, let's look at your testimony concerning this when you were asked questions by the prosecution. And I'm referring to testimony from the 3rd of September, 2012. It's page 14 in English, the transcript. Khmer, it's 008444181. French, it's also page 14. You were asked the question. In fact, they read you this section. And it was verbatim. It was read to you. And then you were asked, what else can you tell us about this telegram translation unit? Did you know where it was based and how many people worked there? Now let's look at your answer that you gave us only a couple of days ago. With regard to the telegrams communications and Mr. Ingshari, I am afraid I do not recall or whether there was any such telegram decoding unit at this office. Question. So, we could correct your prior statement then, that you didn't know whether there was a telegram translating unit at the Ministry of Foreign Affairs. Would that be correct? Answer. I am not sure on this. That's why I'm not testifying on something that I am not clear. Do you see the questions that were posed to you? And do you see the answers you gave us a couple of days ago?
Yes, I do.
And when you gave those answers, were you being honest and truthful?
Yes, I was. And it was the truth.
Thank you. Now, later on, you are asked a question, and this is on the September 4th, the next day, the following day. This would be on page 37 in English. Khmer is 00844480. French, it's 40 to 41. You were then asked a question by the civil party lawyer. And it starts with, my next question is related to your testimony. From your testimony from the 29th August up to this morning, your response mainly dealt with communications via telegram domestically. What about telegram correspondence between Cambodia and other countries? How was it done? Did any of the telegrams from the overseas sent to 870 committee? Answer. In relation to overseas telegram, I could not grasp them fully, so I am in no position to enlighten you. Thank you. What about the Ministry of Foreign Affairs? Did it ever send any telegrams to 870 committee through your unit, or did they send it directly to 870 committee? And then you state, Ministry of Foreign Affairs was located in Phnom Penh. There was no telegram communication with my team. If not, how did they communicate? That is, the communication between the Ministry of Foreign Affairs and 870 committee, and then you say, I don't know. Now, do you stand by those answers that you gave, that you are not in a position to grasp the subject matter fully as far as overseas telegrams?
Yes, I still maintain my statement. As I said just now, I once went to the ministry to explain decoding of telegrams. At that time, it was located at the former Prime Minister's office. It was known by the code name of B1.
And can you please tell us what year might that have been? And with whom did you speak?
At the time, I taught a gentleman by the name of Bun. And later he was sent to the Cambodian embassy in Bangkok. Actually, that training did not last long. It actually took only half day.
And normally, how long did trainings take place in order to someone learn how to decode? Because you told us it was a very complicated process.
Yes, it is. It was a complicated process, but the gentleman I said had a very firm foundation, so he was fast to learn. It took us rather short to train.
Okay, now answer my question. How long did it normally take to train someone?
As I said just now, it took only half a day, starting from 7 and ended at 11. They could grasp the basics.
Maybe something is being lost in translation. You said this person had a foundation. You gave us a name, which we'll try to check. But I'm asking you, how long would it normally take to train someone to become proficient like you were?
Uh, 4 hours.
So normally it would take somebody only 4 hours to learn this very complicated process, the average person.
Yes, that is correct for those who have the educational bar.
All right. And when you say educational bar, those who can read and write?
No, they were not confined to the ability to read and write, but they were students at the university.
All right, thank you. Now, in your interview, there is something that never made it onto the summary. It's on the tape, where you indicate that you only knew technical matters. Would that be correct? that the extent of your knowledge was only to technical matters about the deep and important information that you did not know. And this would have been during your first interview, right around the time that it was about to end, approximately 11:15, 18 February 2009. We have the tape we can play. Do you recall telling this to the investigators, that your knowledge was limited to technical matters?
Yes, I confirm that that was within my knowledge in terms of technical aspects, but as for political aspects, I did not have knowledge of.
All right. Well, let me just get a little ahead of myself. So if you didn't have knowledge about political matters, when you're analyzing documents and you're giving your opinion as to what the document that is shown to you, how it should be interpreted, how are you doing that unless you are I would say, well, I can't use the word speculate, but how would you do it if you don't have any actual knowledge or training or background?
President, witness, please hold on. Mr. Prosecutor, you may proceed.
I think the question is too vague and frankly unfair to the witness. He was asked to analyze and describe numerous aspects of various telegrams. If there's a specific telegram and a specific analysis which my friend wishes to impeach, that specific instance should be put to the witness. That's all I would say. There was extensive description given of telegrams. We would say, well, I'll stop there in order not to be accused of broadcasting to the witness. I think my friend should refer to specific examples.
As I noted that we would be getting to that, I'll move on. And now that we both agree that concrete examples should be shown, I'll do that after the lunch break. Now, in your testimony, it would appear that, I don't want to go into all of the mechanics, but at some point, after you translate a telegram, you decode it, you give it to a messenger. Is that correct?
Yes, that is correct.
Now, once you give it to that messenger, did you ever follow the messenger and follow the message itself to see where it actually went?
I did not follow up. As for the messengers who came to fetch the telegrams or letters from our unit, they would send it to the post guard in front of K1.
Right, and I'm going to go step by step. So the messenger would take the message, go to the post, and drop off the message or give it to someone. That's your understanding back then of what happened.
Well, the messenger would drop it at the post, and then the guards would immediately relay this message to...
Step. Now, did the messenger ever go into the K1 compound, to your understanding or to your knowledge?
Our messengers were not authorized to enter the premise.
Were you authorized to enter the premise? And if so, how often did you enter the K1 premises?
I was authorized to enter, but only when Pon summoned me to a meeting.
All right. Did you ever enter the K1 premises with a message that you had decoded in order for you to personally deliver it to the targeted person or persons?
Yes, there were some instances as such, following the decoding of messages, and coincidentally they asked me to attend the meeting. Then in that situation I did not have to send the messages through messengers. I would bring the message by myself and hand it in to Pon.
Okay, so you would hand it to Pon, but you would not hand it to the targeted people that supposedly the messages were headed for. The extent would be you would hand it to Pon.
Yes, because Pon was my direct supervisor, I could not submit it to any other person.
All right. Now, can you please describe the premises of K1? How many buildings were there?
Within the compound of K1 office, at that time there were only 2 multi-story buildings.
And what about where Pon worked? Was there not also another small building or small place where he worked? Or did he work in one of those 2 buildings?
Well, Pon's office was on the 2nd floor. It was at the far end of the building. It was on the 2nd floor.
Of which building? There were 2 buildings, you told us. Which of the 2 buildings?
It was in one of the building. If we enter from the entrance, then it was the building opposite the sun.
That's your answer? Okay. Now, you tend to indicate when the messengers were provided to the messengers, they would simply drop them off, or if they were coming from K1, they would pick them up at the gate and then deliver them to you. Is that right?
អត់អញ្ចឹងទេ No, that is not correct. Actually, whenever they wanted any message decoded by my unit, for short messages they would assign us through telephone, or they would relay it through telephone, but for longer messages they would send it through messengers. So there was no any one particular procedure for that. For short messages they would make a telephone call to my unit, and there was instances when Pon himself brought the messages or telegrams to my unit in person.
And as I understand it, what you were dealing with on the outside were messages that were not highly confidential. At least that was my understanding of it, of your testimony. Is that right?
For less urgent messages, they would courier through messengers from K1 to my unit. But once the messages were of urgent nature, then they would bring it to my unit myself and themselves, and they told us to put the code letter D on the urgent document, and the author of the document also came to my unit to provide additional instruction.
Now, Pon was your supervisor. Did Pon disclose to you his activities within K1, what he was doing, to whom he was speaking, what he was learning from the inside? Did he disclose those matters to you at any point?
No, he did not disclose his responsibilities, duties.
And did he ever disclose to you who he was meeting inside K1? What sort of instructions he may have been receiving? How K1 actually operated? Keeping in mind that you told us how important secrecy was.
There was a principle of utmost secrecy for those who had to work with confidential messages or documents. We had to adhere to three principles of secrecy. Whatever we were not supposed to speak out, we must not speak out. Whatever we must not ask questions, we had to keep silence. So we did not know, we did not hear, we did not see, and we did not speak for the matters that were considered of utmost secrecies.
And from your experience in working with Pon and Te, did they abide by those principles? At least with respect to you.
He led me by example in that situation, because he did not say anything at all concerning whom he reported to or whom he talked to about the internal secrecy of the work of K1. He never disclosed any information to me.
And one final question before we perhaps break for lunch. This is the same individual that you had worked with prior to 75 when you were at B20. Is that right?
No, that is not the case. I worked with him from 1973, but it was not in B20. I separated from PON in late 1974, and then we moved our office from the Maki Jungle to B20. So I worked with PON from late 1973 until late 1974. Then we parted. We work in different places. He went to a location west of Phnom Penh, and I moved to B20, which was located in Banana Mangrove.
Right, and thank you. I stand corrected. And it was at B20, I believe, when you were working, that's when there were three, the task was divided into three different sections. One actually that would decode. They were in different locations, different individuals working on decoding, broadcasting. Is that correct?
Yes, that is correct. The units were separate, and we did not have any contact with each other. We did not see each other's faces from one unit to the other. At my telegram unit, it was stationed in one separate place. And once I received information from the battlefields or the front, then I would arrange it for broadcast. But it was in a different place. And I think I made myself clear in my earlier testimony that we never saw each other's face, people who worked in those different duty stations.
And was that because of the important principle of secrecy?
Yes, that was the arrangement. It was to preserve the principle of secrecy.
Mr. President, I see that we're 5 minutes after 12. This may be a good time to break for lunch.
President, thank you, witness. The time is now appropriate for lunch adjournment. The chamber will adjourn from now until 1:30 this afternoon. Court officer is instructed to facilitate the place for the witness to rest during lunch break and have him back to this courtroom before 1:30. I note the defense counsel for Mr. Nguyen Chia is on his feet. You may proceed.
Thank you, Mr. President. I have three very, very brief points to make before we break for lunch. The first refers to a decision of the pretrial chamber, and I'd like to just make a note of that for the record, and I will try and speak slowly. I'm referring to document D375/1/8, and this is a decision on an appeal against a number of requests for investigative action made by the defense, made by the Nguyen Chia defense in this case. And those requests concerned the recalling of witnesses to canvass the kinds of issues we've been debating this morning. those requests were all rejected for various reasons, and we appealed them all. And in dismissing our appeal, I'd just like to tell the Chamber what the pretrial chamber said. This statement by the co-investigating judges, and that referring to the ruling made by the co-investigating judges, means that if they properly exercise their discretion to refuse a request for investigative action, such as to interview or re-interview a witness, the trial stage affords the defense, quote, every opportunity to contest the evidence. And let me repeat that, every opportunity to contest the evidence, including the possibility to, internal quote again, request the trial chamber to summon any of the witnesses the co-investigating judges have decided not to interview, crucially here, or re-interview, the basis of those requests that we made. And finally, the point made by the co-investigating judges, with which the pretrial chamber agrees, is that the trial stage is an additional and alternate forum for the defense to contest the reliability of evidence. Now, this is a decision of the pretrial chamber based on a decision of the OCIJ, both organs operating in that system that Judge Cartwright described as the civil law system, the system that's applicable here. So that is the basis on which we proceeded at trial to believe, reasonably I think, that we're able to explore these issues with the witnesses on the stand. And perhaps one final point on this, perhaps this will answer partially at least Judge Laverne's question about what the defense was doing during the investigation. In our case, we were filing 25 requests for investigative action, and that took quite a lot of time. And that's not to mention all the additional requests filed by the other defense teams. So I know this issue is a bit of a bête noire with the chamber, but I just think I need to make it clear it's a very important one for us, and I wanted to get that pretrial chamber quote on the record. My next point very quickly goes to the definition of the word speculate. As I understand the English definition of that word, it encompasses a situation where a conclusion is based on little or insufficient evidence, not, as Judge Cartwright suggested, that it only encompasses a situation based on no evidence. That's my understanding of that word in the English language, and of course it can be qualified with all sorts of adjectives, bald speculation, reasonable speculation, what have you, but the word itself does not mean what Judge Cartwright said it means exclusively. And that's our position for the record. And finally, before I forget, I've just been informed that our client is suffering from a backache, a headache, and a genuine lack of concentration. And for those three reasons, he would like to spend the afternoon in the holding cell. And that is our application for the morning. Thank you.
President, the Chamber notes the request by Mr. Nguyen Chia through his defense counsel to follow the proceedings remotely through audio-visual link for the remainder of today's proceeding due to his health reason. And the Chamber grants this request, and Mr. Nguyen Chia may follow the proceeding from the holding cell downstairs, where audio-visual means is connected for him to follow the proceeding for the remainders of the day's hearing. However, the Chamber requires the defense team for Mr. Nguyen Chia to submit to the Chamber the waiver with the San Prino signature by Mr. Nguyen Chia, and AV assistants are instructed to connect the audio-visual link for Mr. Nguyen Chia so that he can follow the proceeding remotely from his holding cell. Security guards are instructed to bring the co-accused, Mr. Nguyen Chia and Mr. Kieu Sampon, to the holding cell downstairs. Mr. Nguyen Chia is to remain in that holding cell for the rest of the day, where he will be connected to the audio-visual link to follow the proceeding, and Mr. Kieu Sampon is to be brought to this court room by 1:30. The court is now adjourned.